Dear friends and colleagues, a very warm welcome here to Park Lane for our WilmerHale Scholar-in-Residence Seminar 2013. I do apologize for my voice. I have a little cold. I hope I'll make it through this evening. Regulars of our Scholar-in-Residence seminars will have noticed that this is the second seminar that we have with Professor Jose Alvarez as our keynote speaker. Indeed, last year, exactly the same day, it was also the 17th of December, he was presenting his paper on the various investment cases brought against Argentina. There is actually a recording of that presentation on our website, if any of you are interested to have a look. This 2012 event was tremendously successful. It was oversubscribed, and the recording was viewed numerous times on our website. So we're absolutely delighted that Jose Alvarez has again accepted our invitation to come back tonight. WilmerHale co-hosts the seminar tonight with two partner institutions with whom we have very close links. This is Queen Mary's School of International Arbitration on the one hand, and the Investment Treaty Forum at BICL at the British Institute of International and Comparative Law on the other hand. So I would like to welcome to that effect all the members of the Investment Forum here tonight, as well as my colleagues from Queen Mary, and of course, in the first place, Professor Lucas Mistelis, who is the director of the School of International Arbitration, and who will be doing the closing remarks later tonight. Before we start, let me just say a couple of words on our WilmerHale Scholar-in-Residence program. It is actually a very unique program, allowing academics from all around the world to join WilmerHale's arbitration team for a certain period of time. We have currently Professor Jose Amado from Peru, our first scholar-in-residence from Latin America. We're absolutely delighted to have him around. He splits his time between WilmerHale, but he's also a visiting scholar at the University of Cambridge, and more precisely at the Center for Latin American Studies at the Lauterbach Center, where he conducts a very interesting research on the use of treaty arbitration or arbitration agreements for social conflict. So I think we have a very interesting topic for our next Scholar-in-Residence seminar. In the past, we also had other very prominent scholars. We, for example, had Professor Sonaraju from the National University of Singapore. We had Professor Linda Silverman from NYU. We had Professor George Jackson from Georgetown, and Professor Yoonji Kim from Yonsei University in Seoul, Korea. And of course, just to mention a few, there were others. And of course, not to forget Jose Alvarez from NYU, who was our scholar-in-residence last year, and whom I now have the pleasure to introduce as our keynote speaker tonight. Jose Alvarez is the Herbert and Rosie Rubin Professor of International Law at NYU, New York University Law School, where he teaches international law, foreign investment, and international organizations. He was, before that, also at Columbia Law School, Michigan University Law School, as well as Georgetown. Prior to entering academia, Professor Alvarez was, among many other things, an attorney advisor at the U.S. Department of State, where he worked on cases before the Iran-U.S. Claims Tribunal, and he served on the negotiation teams for negotiation various bilateral investment treaties, as well as the Canada-U.S. Free Trade Agreement. He was educated at Harvard Law School as well as Oxford here in this country. He has written extensively on investment arbitration and international law. To list those publications would probably fill our evening. But let me just mention one, which is his recent Hague lecture, which is entitled The Public International Law Regime Governing International Investments, and which is available as a book. Professor Alvarez will speak about the following topic tonight. It is entitled Crossing the Public-Private Divide, Saipem versus Bangladesh and Other Crossover Cases. He will be examining this fairly recent group of awards in which parties have used investor-state arbitration as a vehicle to enforce international commercial arbitration awards. based on those so-called crossover cases, he will be asking a number of very thought-provoking questions, including whether the divide between commercial arbitration on the one hand and investor-state arbitration on the other hand is really as clear, as meaningful, as watertight as it is sometimes described. Before we start, just one very, very brief housekeeping remark, and that is that, like last year, we will record tonight's presentation. So with the permission of Professor Alvarez, this will be available on our website in a couple of days. So now, without further ado, Jose, the floor is yours.
Thank you. Well, I don't think my kid will be looking at it in YouTube anytime soon, but I appreciate that. So I think my presentation will raise more questions than answers. And let me take a step back. It was initially presented at the ICA conference in Singapore, and it's now published in the ICA Congress book. So if you look it up, it'll be there in the latest issue, so you can actually see the remarks. And the background is I was invited by Gabrielle Kaufman-Kohler to comment on Saipem v. Bangladesh. Now, if you take a step back, which is quite interesting, Gabrielle Kaufman-Kohler served on Saipem v. Bangladesh. So she was expecting me to do what? Criticize her in front of her as a moderator on a panel. It was one of the more awkward settings I have ever been exposed to, but it was an opportunity to learn about a set of cases that I normally would not have noticed, but it is basically, this talk is about that divide. So as Maxie suggested, most people have suggested that commercial arbitration and investor-state arbitration are two separate worlds. Tony Landau, Gus Van Harten, people as different as that, have suggested that whereas commercial arbitration is merely another way of settling a private dispute, investor-state arbitration, especially when it emerges from a treaty, like a bilateral investment treaty, is a species of public adjudication. And the publicness, which I've been somewhat critical of because I'm not sure of what it means, but it is said to come about because it is public because you have a government on one side as a litigant. You may also have regulatory issues of wide public interest are impacted. It is public because it has greater potential effect on the public fisc. The awards are perhaps larger. And it is public, it is said, because it generates precedent. That is, since many of these, if not all of them, are public awards, there is a tendency for precedent to be established. And so what we have is this publicness that has generated, and I apologize, but this paper is from my perspective, from the investment perspective looking out, and I look to the commentators perhaps to show us how the commercial arbitrator world looks at these very same cases. But from my perspective, the international investment regime is in a bit of a scholarly and perhaps sovereign backlash, and these cases may be symptomatic of that backlash. So what we have, there's growing concern, those of you who don't follow this regime, that these public awards are destroying the ability of states to govern themselves. Sovereign policy space is threatened. There is concern that these awards are biased in favor of investors. There is concern that it is not generating predictable rules of the game, despite the jurisprudence constant. It is not as constant as some people would like it to be. That is, these are ad hoc arbitrators, and sometimes they disagree with one another. So what the cases that I'm referring to, and Maxie referred you to some of them, they're basically about 6 or 7 cases that are crossover cases of that type, but there are also cases where commercial arbitration awards, the failure to enforce them, are then pursued in European Court of Human Rights. Those are also crossover cases. So those cases generally are the ones that I'm talking about, and I think they raise questions about the alleged divide, public-private, but it also raises questions about the legitimacy deficit of this regime and whether it will grow worse with time because of these cases. Now, the suggestion that these regimes are entirely distinct that is also followed by the idea that they follow different interpretive techniques. And then some would even suggest that you need distinct sets of arbitrators with distinct sets of skills, distinguished by way of their background and training. And I would suggest that all of those possibilities are challenged by these group of cases in which basically national courts and how they respect or enforce commercial arbitration awards leads to second bites at the apple in the form of investor-state arbitration, or now challenges before the European Court of Human Rights. Now, Michael Reisman is the one that coined the term crossover cases, and he wasn't happy about them. We'll talk about why Michael is not too happy about them in a minute. I will treat them as cases that challenge the conception of a very specific demarcation, a dichotomous public-private divide between commercial and investor-state. I will suggest that it is premature to say that divide exists, but it is also premature to suggest that there will be a flood of these cases, or that because of that flood there will be an even more backlash against the regime. And one of the reasons that I don't think there will be a flood of cases is, as Professor Mastelis on this panel has written about, there are precious few opportunities to have to resort to the second bite. That is, most commercial arbitration awards, as you all know, are voluntarily complied with. There are precious few of them that you get to the point where you're desperate enough to have to go to either the European Court of Human Rights or the investor-state procedure. So we are likely to always be talking about only a few of these cases, at least until there is a major problem with the commercial arbitration enforcement regime. But I would suggest that what these cases, at least these few cases, suggest that what we have is a public-private continuum, not a sharp divide. The cases that I have in mind for the investor side are Saipem v. Bangladesh, Romac v. Uzbekistan, GEA Group v. Ukraine, ATA Construction v. Jordan, Frontier Petroleum Services v. Czech Republic, and a very interesting case, White Industries Australia v. India. And then the crossover cases on the European Court of Human Rights, for those of you who might want to look these up, Strand Greek Refineries v. Greece, Kinstib v. Serbia. There are others. Regent v. Ukraine from 2008 is yet another. Now, in three of the investor-state cases, Romac, Frontier, and GEA, the claimants failed either for jurisdictional reasons or on the merits in their effort to use a particular bilateral investment treaty to secure recognition or enforcement of the underlying commercial award, and their claims were dismissed. But in the other three, Saipem, ATA, and White, the claimants prevailed. And the claimants before the European Court of Human Rights prevailed in the two cases that I'm talking about, and they were able to use the European Court of Human Rights to challenge a lack of enforcement in whole or in part of commercial arbitration awards. The cases in which the claimants prevailed in securing a second look at national courts' actions are particularly interesting. The Saipem case and ICSID tribunal found a Bangladeshi court's failure to recognize an ICC award to constitute an expropriation under the Italian-Bangladesh BIT, and ruled that the claimant had therefore was owed compensation equal to that under the ICC award. The ATA ICSID tribunal found that the extinguishment of the right to arbitrate was itself a violation of the BIT's fair and equitable treatment clause and granted the claimant the right to arbitrate. In White Industries, an uncentral tribunal accepted the claimant's argument that a 9-year delay by India's courts in responding to set-aside proceedings involving an ICC award constituted a breach of the bilateral investment provision, ensuring, quote, effective means to assert justice and enforce rights. That is, an effective means clause in a bilateral investment treaty. None of these decisions, interestingly enough, involve what would have been the most obvious, a denial of justice claim. And that's the one that most people would have written about had they approached the cases without actually looking at them. But in fact, the White decision specifically rejected a denial of justice claim, ruling that denial of justice provides a rather narrow set of rights to the investor, and therefore correspondingly greater sovereign discretion than does a BIT's effective remedies clause, which is a separate guarantee. Now, the two decisions in the European Court of Human Rights are, I suspect, a little less familiar to the arbitration crowd, perhaps some in this room. So let me just mention them a little bit more. Stan Creek Refineries v. Greece, Strand sought a remedy before the European Court of Human Rights because of Greece's failure to enforce arbitral awards growing out of contractual dispute between the parties. In that case, after Strand had obtained an arbitral award in its favor, the Greek parliament had enacted a law that permitted the revocation of the contract, including its arbitration clause. That law led the Greek courts to quash the award. Strand claimed a violation of Article 6 of the European Convention of Human Rights, which guarantees a fair and public hearing in the determination of civil rights, including presumably your right to have your arbitration award enforced. They also cited Article 1 of Protocol 1 of the European Convention, which bars the deprivation of possession or property rights subject to certain public policy exceptions. The European Court of Human Rights found that quashing the arbitration award did indeed deprive the claimants of a fair trial, and that the Parliament's enactment of the law constituted an unjustified interference in the claimant's underlying property rights, which the court included to be the award as a possession under the European Convention of Human Rights. In Ken Stib v. Serbia, claimants sought a remedy in the European Court of Human Rights for the failure of Belgrade courts in ordering compliance with part of an arbitral award that had been rendered between Ken Steb and its partner in a joint venture with Genex to jointly operate a hotel, casino. And the arbitration court of the Yugoslav Chamber of Commerce had ordered repossession of the casino as well as financial compensation for the breach of contract. The Belgrade court ordered the payment of damages, but did not enforce the repossession order or any aspect financially for that. And the European Court of Human Rights found that the claim established in the arbitral award was indeed a possession within Article 1 of the Protocol 1, and that the failure to fully enforce that award constituted a violation. It ordered further compensation in lieu of the order to permit the applicants to take control of the casino. Now, the many fascinating questions are raised by these decisions. This obviously, all of them are second looks at what a national court does with respect to arbitration. There are many different ways you can consider that second look. You can say that this is another enforcement tool that commercial arbitrators now need to consider. And in fact, perhaps clients are well aware of these cases, especially if they watch this on YouTube, and will ask you why you haven't pursued their unsuccessful effort in this way. So it may be part of that toolbox that you will have to pay attention to if you're in the commercial arbitration game. And this raises another question, which pits Michael Reisman with someone else in this room, Professor Radicati, who has written on the other side of this issue, which is the question of whether this second look is consistent with the architecture of the New York Convention. Reisman argues that these cases threatened the primacy of the national court of the arbitral forum, because, as he sees the convention, if that court decides to vacate an award, to annul an award, that's the end of the story. And there you should not be able to turn to either the European Court of Human Rights, presumably, or the investor regime to undermine what he considers to be the basic architectural scheme. And at least one of these cases, the ICC tribunal in Kaliningrad v. Lithuania held that it had no jurisdiction under a bid to provide a means of recourse against a state acting in accordance with its obligations under the New York Convention, and the Paris Court of Appeal affirmed that judgment, so presumably Michael Reisman has at least that case on his side of the ledger. Quite apart from whether recourse to bid arbitration is or isn't consistent with the New York Convention scheme, there are those who raise questions about whether going to, say, either the European Court of Human Rights or investor-state arbitration is really the appropriate venue for considering these cases. And some would put it in a somewhat different way. There's the question of expertise. Are the experts, are the arbitrators who are not commercial arbitrators in, say, an investment case, really in the position to judge what either the New York Convention means or whether it has been properly or not properly applied, and some of these cases do address whether the New York Convention was properly applied below in the national court. There is also other questions. What is the level of deference that either the European Court of Human Rights or an investor-state tribunal should owe to a national court? There are some commentators who say that you do owe a level of deference to at least a national court in these cases. And then there are those who say that all this will do is render all the complaints against the investor regime all the more apparent. That is, it will seem all the more true that this is a scheme that is biased in favor of investors, that this is a scheme that generates inconsistent awards, that this is a scheme that narrows sovereign policy space, and most egregious of all, that this is a scheme that leads to appellate review when none is expected in national courts. They raise worries about the internal disharmonies of the investment law and whether they are consistent decisions. For an investor lawyer like myself, they raise really a number of intriguing questions as to the meaning of fair and equitable treatment, the full protection security clause, expropriation, effective remedies clause. That is, now we're seeing decisions that put new facts in question and thereby raise questions about whether our understanding of what an expropriation is the same now that we have Saipem v. Bangladesh basically telling us that an expropriation that is less than the full amount of the award is actually a taking. There are also questions about pleading. That is artful pleading what is at stake here? Does it all depend on being able to raise the right set of guarantees in each of these cases, or should arbitrators strive for uniform results even when the claimants do not engage in this sort of artful pleading? And then there's this question about that is for investment lawyers pending since the Lowen case, which is when you raise a question about denial of justice, or when you raise a question about what a national court has done. The Lowen decision in the NAFTA context said that exhaustion applies, that you should provide the state with the opportunity to take the case all the way to the end of the road, the Supreme Court of India, for example, if necessary, because that should be built in even when a bilateral investment treaty has a fork in the road clause, that this is built into the substance of effective remedies clause or a denial of justice clause. And when you think about that in this context, it doesn't make a lot of sense. 9-year delay in Indian courts is a 9-year delay, and then if you add on to that, well, you need to exhaust that in order to bring an investment claim. You are getting to be a very exhausted claimant indeed. So I'm not sure that exhaustion should be brought in, but it's certainly a lingering question on that. And then there are, of course, questions about, well, what kind of judicial action should prompt an investor challenge for example. What kinds of delays, not just how long, but what about an attempt by a court to enjoin an arbitration? For example, should an anti-suit injunction against arbitration itself be seen as a violation of not just the New York Convention, perhaps, but also of investment treaties? Certainly Steve Schwabel suggests that that should be the case. And then there is the question of whether this Pandora's box that has been opened will generate fragmented decisions about what a possession or a property right is, as between investment regime and the European Court of Human Rights. So, for example, some of these cases suggest that an investment is not an award itself. The award isn't the investment under ICSID or under the Cellini factors that some people think applies to ICSID, or even under the language of a bilateral investment treaty that talks about investment or a right to property. But yet, in the European Court of Human Rights, it seems to be accepted that that is a possession meriting protection under Article 1 of the protocol. Will those cases now affect the definition of investment for purposes of the investment regime, now that the two regimes are sort of joined this way? Now, I don't have time, and I know I'm already running out of time, but what I wanted to suggest is that although there's a lot of literature now, and on the plane here, I looked through all the recent, and there's now far more articles on these 6 cases than there are cases. But I'll just give you a flavor of the ones who praise this. Gabrielle Kaufman-Kohler, of course, praises this. It says that the bridging the two sides will help to integrate and defragmentize the regime. And she argues that there is a long-standing tradition of using diplomatic espousal to protect commercial arbitration and the right to arbitrate. See Socio-Belge case from the PCIJ, for instance. She also thinks that investor state is a perfect vehicle to pursue claims of what she thinks are bad faith. That is, good faith and going against abuse of power is what she sees happens when national courts violate the New York Convention's rules and vacate award or extinguish award or set aside an award when they're not supposed to do that. And she says that under no circumstances should these be viewed as the same thing as appellate review, and therefore that's a canard that is asserted. William Park, who writes in the United States, says that what's wonderful about these cases is they provide the missing remedy that is not in the New York Convention. The New York Convention doesn't tell you what happens when a state fails to do what it's supposed to do. And in those very few cases, when you actually have all the preconditions of investor state fulfilled, the host state is actually the one that is on the hook. There is protected investment. There is also the right that you can assert in the treaty. Then you have a remedy. Unlike, he says, regretfully, whenever the United States violates the New York Convention, and he cites multiple cases in which the U.S. has done so, and there is no investor state protection in sight because, say, the NAFTA is not involved. And then there's Michael Goldhaber, journalist. He says this is another way of looking at this. This reflects the increasing phenomenon of arbitrators exerting power over national courts. So that rather than vice versa, this is what we always think about. And so his example is Chevron v. Ecuador, where, of course, you don't get what you want from the U.S. court in terms of enjoining the planet, but you can get an arbitral tribunal to issue orders against the Ecuadorian courts. And so these cases are another example of arbitrators finding power where they never had it before. And they are, in fact, he says, engaging in the second guessing of what national judges do. And you can call it what you want, but it is, he says, appellate review. And he does assert that there will be sovereign backlash, and therefore, says Mr. Goldhaber, who after all is a journalist, not a scholar, but never mind, he says that that leads you to an appellate body for the investor-state regime. That is, these cases alone raise the legitimacy concerns that should drive us to creating an appellate body. Another set of authors connects these cases. I'm just mentioning this because these are different angles to look at this. Another set of authors connects this to a long line of international law precedents in various courts and tribunals that protect contractual rights, and therefore says that a contractual right is also an arbitral right, and therefore you should be able to do it. My own view of these cases is that it's too early to say that they're a fundamental threat to the investor-state regime, or that there will be a flood of cases for many, many reasons on that. But two that I highlight in the paper are the cases themselves pose such fundamental hurdles for the claimant that it will be, I think, a rare case where they will find protected investment, because if you go through the cases, you'll see that White and ATA are on one side of the picture in suggesting that even an award might be considered an investment if so defined in terms of the bilateral investment treaty, whereas GA and some of the other cases, and even Saipem itself, refuses to say that the award is what's at stake. You have to look behind the award and find that the underlying award is based on an investment, and that could bring you back to the Cellini factors. The other hurdle, and it's a major one, and it's certainly stressed in the White case, is there a bit violation? And that is also extremely difficult, even in the cases where the claimant won. So even in the White case, they go through many, many arguments. They reject expropriation. They reject denial of justice. They reject the international minimum standard on the premise that the claimant should have envisioned and should have foreseen that, yes, it's going to be a little troublesome to get an arbitral award enforced in the courts of India. He shouldn't have had an arbitration there to begin with. If that was going to be a problem, he should have foreseen that problem. And therefore, they denied that part, but said, and basically said, that the denial of justice claims and fair and equitable treatment claims were contextualized. You have to put it in the context of India. And therefore, you don't get the same fair and equitable treatment in the courts of Norway or another arbitration-sensitive state that you would in the courts of India. The only thing that saved the claimant in White is to be able to use the MFN clause to draw from another treaty, the effective remedies clause, which that court said, consistent with an earlier iteration of Chevron v. Ecuador, was a lex specialis, special right that is not contextualized. It's an absolute right to an effective remedy, and 9 years is too long, said White. So those are the two major hurdles imposed by these cases. I don't, although I have real problems, and we can get into in the discussion because I know I'm running out of time, I have problems with the Saipem's decision that was a violation of the actual bit in Saipem, because the only jurisdiction that the arbitral body had was over expropriation. None of those other rights was at stake. And so when you look carefully at what Saipem did, it basically said that this was an expropriation because the courts in Bangladesh acted so egregiously. That's basically what it says. It's an abuse of power turns into an expropriation. I'm a little uncomfortable with that as an investment lawyer. That is, we have plenty of cases of abuse of power, but up to now we have said that has to be an FET violation or something else. If that's not in play, then what you really need is a total deprivation of property. There are also questions you could raise in some of these cases, and I'll mention it here because that's likely to provoke some people, and I like to provoke, and that is the damages. So look at the damages in these awards. Even if one assumes that Saipem or other cases suffered from an expropriation, what was actually the worth of property right that was taken in these cases? If what was taken in these cases was the contractual right as crystallized in the ICC award, why did the tribunal not consider the fair market value of that right? Why not adopt the usual approach of determining the fair market value of that contract, involving the calculation of the present value of net future cash flows subject to a discount rate, including the risk of default? If, on the contrary, the property that was taken was essentially the ICC award itself, why should the claimant receive as compensation, under the principles of social factory, an amount equal to the full ICC award, when in the real world in which we live, investors routinely discount the value of such awards, given the difficulties and, yes, the uncertainties of enforcing them? And in a real world where even successful investor state claimants, see CMS and my presentation from last year, they sell their awards on the secondary market for a fraction of their face value, there is a serious question of what is the fair market value of an unpaid ICC award. Let me just stop there before I get tossed out of the room.
Thanks so much, Jose, for this wonderful presentation, very provoking and food for thought, I'm sure, for the discussion. I actually totally forgot to check my watch because I was listening to you so attentively. So you could have gone on forever. I had no idea.
My time.
Before we open the floor for questions from the audience, I would just like to invite our two commentators for tonight, Professor Lord Collins and Professor Gary Bourne. Both of them don't need an introduction, just very briefly. Lord Collins, of course, is a former justice at the UK Supreme Court. He sits regularly as an arbitrator based at Essex Courts Chambers, and he's a professor at University College of London. He has written extensively in the area of international arbitration, international litigation, and private international law, and of course is the editor and author of the preeminent Dicey, Morris and Collins on Conflicts of Law, one of my preferred books ever. Gary Bourne, of course, is the head of international arbitration here at WilmerHale. Our arbitration practice is based here in London, but actually encompasses a number of people, actually about 80 people, in other offices around the world, including New York, DC, Frankfurt, Beijing, and others. Some of them are here tonight, colleagues from further afield. Gary's 2-volume treaty on international arbitration, or referred to internally as the Bible, will be coming out in a new edition, the second edition, early next year, so keep tuned, as they say. Lawrence, Collins, Gary, please. For you.
Thank you very much. My first comment is that I think my understanding is that 9 years for India is actually quite short. Maxi very kindly referred to the material on private international law, but my first love was public international law. I was a pupil, as John Tackerbury knows, of Clive Parry, and then I went to Columbia Law School and studied under Wolfgang Friedman and Oliver Lizitsyn. And then on my first day as a trainee solicitor, I was invited by Francis Mann to join him on the Barcelona traction case. And that's by way of background to the fact that I just want to pick up on one thing, really, since time is very short, which is why it's rather surprising that the traditional principles of denial of justice haven't played a major role in this area. And it's surprising because denial of justice in this area goes back a very long way. The earliest I could find was something in Moore's arbitration, an 1890 US-Chilean Claims Commission decision, which said that suppression of an arbitral tribunal was a denial of justice. And in the 1930s, we have the Lozinger case in the permanent court, where the Swiss agent, the famous Georges Sosa Hall, said that breach of an obligation by a state to arbitrate was a repudiation of a state's duty to aliens. And the same point was made in the Lebanese cases by France in both the 1930s and the 1950s before the Permanent Court and the International Court. And the most famous example of all of this, of course, is the Anglo-Iranian oil case. Most of you are too young to remember it, so I'll just remind you that in 1901, William Darcy Knox, or is it Knox Darcy actually, William Knox Darcy, who'd made a fortune in mining in Australia, like many people today, got a concession covering 480,000 square miles in what was then Persia. He discovered oil in about, I think, 1908 or 1909. In 1931 or 1932, the Persian government threatened to nationalize terminate the concession. A new concession was entered into in 1933 between what was then called the Anglo-Iranian Oil Company, now BP, of course, under which it was concluded under the auspices of the League of Nations, and in this concession agreement, not unnaturally, the arbitration clause provided for each party to appoint their own arbitrator and for the two to appoint an umpire or chairman. But it also provided that if either party did not appoint an arbitrator, the appointment would be made by the president of the Permanent Court of International Justice, or if the president was of the nationality of either of the parties, by the vice president. In 1951, Dr. Mossadegh nationalized the oil fields and terminated the concession. The company sought arbitration. The Iranian government refused. The company applied to the president of the International Court of Justice and subsequently to the vice president when Lord McNair became president, was therefore disqualified. Both of them, which is a very sorry story, which there's no time to go into, refused to make the appointment. The British government brought an action in the International Court against Iran, obtained interim measures, but failed on the jurisdictional hearing on the ground that the concession, although entered into with the participation of the United Kingdom government and under the auspices of the League of Nations, was not a treaty within the meaning of Iran's acceptance of jurisdiction. Judge Carnero, dissenting, said that the case was a very, very clear case of denial of justice by refusal to arbitrate, which was the main claim of the United Kingdom government on one of its heads. That's a sorry story. In more modern times, we see that the American Law Institute Restatement Second and Restatement Third both say that refusal to arbitrate is a denial of justice. So far as awards are concerned, there is not very much material. The Soccerberge case is a case, I think, of an award, but there was no decision. It was just a position taken by the governments recognizing that refusal to enforce an award might be a denial of justice. The Restatement Third says it is. What is striking, I think, about nearly all the cases, I've looked at all the cases that Jose referred to, and all except, I think, Frontier Petroleum and the Czech Republic are cases of state entities. The question of where you have a private entity, I think denial of justice is much harder, except possibly in the enforcement of an award, possibly. But all of the cases are state entities under the control of the state, and I would have thought that there's a very serious argument for denial of justice, and I don't see the argument that denial of justice is a less effective remedy.
Those were very thoughtful remarks following on an equally thoughtful and principled speech by Professor Alvarez, and I'll try to be brief. Two comments. One, noting that indeed these 6 cases are pathological examples in the vast majority of international arbitrations, in particular international commercial arbitrations, the arbitrators are appointed, the arbitration conducted, the award rendered, the award paid. That's true in cases between purely private parties. For the most part, it's true in cases involving state entities. It's, of course, not always true. As we know from those 6 cases, there are pathological instances. But as a starting point, it's important to remember that these are examples of the system gone wrong, not the system as it usually works. And it's interesting then to reflect on the excitement, in a sense, that these pathological and somewhat isolated instances have resulted in, and perhaps to reflect on why. When you think about these crossover examples of cases where public rights get resolved in a private setting, both public and private in that sentence being in quotation marks. In fact, crossover cases aren't the exception. They're the rule today. Over the last 40 years, there has developed, not just in the context of bilateral investment treaties, but elsewhere, a whole series of crossover examples, which in many ways, as I say, reflect the new norm, not an exception, not something unusual. And I think it's helpful to sort of put the trend, the crossover cases in the bilateral investment treaty context, into a broader historical perspective for a moment. Lord Collins has begun that from a public perspective, if you will, but there are other examples. We can start in the 1970s with something that's not so immediately obvious as a crossover example, but which in some ways is the best example, and that is the enactment here in this country of the State Immunity Act in the United States, and the Foreign Sovereign Immunity Act in most other European countries, other countries around the world of state of sovereign immunity legislation, all of which took public disputes which formerly would have been cases that were espoused by a diplomatic representative of a foreign ministry before a state, rather than litigated by a private party. Rather, state immunity legislation and ultimately the United Nations Convention on State Immunity created avenues by which private parties could litigate against state entities, including the state itself, quintessentially public disputes. Now, of course, there were in many ways a focus on commercial acts, but there are a number of exceptions, both in UK, US, and UN sources of regulatory actions, the expropriation exception, the tort committed on national territory exception, and as I'll say in a few moments, most importantly, the exception allowing one to enforce arbitration agreements and arbitral awards. It wasn't just that, and of course, as we all know, there are hundreds of state immunity litigations pursued each year by private parties against state entities. At the same time, and it really was around the same time, the New York Convention and legislation implementing that really came on stream in the 1970s and 1980s. It's important to recall that a good 10 to 15% of all international commercial arbitrations, in fact, involve state entities, and in fact involve quite regulatory claims that are infused with very regulatory, very public issues. And again, at around the same time, one saw the GATT framework transformed from essentially diplomatic negotiations in which the accused state had a veto right into the WTO mechanism, in which there was something that looked a whole lot like private arbitration, albeit with an appellate body, and albeit with states acting as the representatives of the private parties, but very often the private parties being the main movers and the main actors in those disputes. Similarly, one saw a number of other specialized tribunals Iran U.S. Claims Tribunal is one example, the United Nations Compensation Commission another example, where private parties were given rights against state entities involving highly sensitive public issues. And so, in a sense, these crossover cases where public rights are considered in a quasi-private setting, an arbitral setting, aren't all that unusual. They are, in fact, part of what has happened over the last 40 years, that happening being a deliberate decision to reduce what some people call the sovereign policy space of states in favor of the legal rights and protections of individuals and companies. One can debate that. That is debated. But it has been a policy choice adopted across a whole range of different areas by, among others, states, in particular by states, in that entire range of fields. It's interesting to reflect for a moment, why is it that bilateral investment arbitration, certainly there are controversies in other fields as well, but why is it that bilateral investment arbitration has attracted so much attention for doing what is actually not something that's exceptional, but something which is, as I put it previously, the new norm? It is in that regard, and I'd like to move on to my second comment, that it's somewhat heartening to see both from Lord Collins and Professor Alvarez these numerous examples of recognitions of what's been called a right to arbitrate. In fact, and Lord Collins looked at this from a public international law perspective, it's interesting to look at it from a national perspective, because the right to arbitrate has actually been recognized for a very long time. The Constitution of Year One in the French Republic in 1793, in Article 86, provided that the right of the citizens to resolve disputes by arbitrators of their own choice shall not be infringed in any matter whatsoever. That didn't last so long, actually, in the Revolution, but that was a hiatus. Come the Geneva Protocol in the 1920s, and a whole series of decisions by, and I was a little bit surprised to find this set of decisions, a whole series of decisions by, among other, Quebec courts, the German Supreme Court, the Bundesverfassungsgerichtshof, interpreting Article 2 of the German Constitution, Hawaiian courts, Venezuelan courts, have all recognized a constitutional right to arbitrate under national law. And the essential theory behind this right is, when you think about it, not at all surprising, and it, interestingly, is quite close to what the tribunals in Saipem and in ATA recognized as being grounded in Article 2 of the New York Convention, which, as we all know, guarantees the right to arbitrate. It requires contracting states to recognize agreements to arbitrate. But the essential theory behind these national court decisions, which I would suggest is reflected in Article 2 of the New York Convention, is that just as constitutional protections guarantee rights of autonomy to such things as choosing your marriage partner, choosing your contracting partner, choosing the way that you wish to express yourself politically, religiously, otherwise, so these constitutional rights of private autonomy also recognize the right to resolve disputes in the way that you choose. Just as it's constitutionally protected, just as there is a constitutional protection for rights to contract, so there's a constitutional protection for rights to resolve contractual disputes, to end your contractual relationship. And I think that, when going back to the pathological starting point that we began in, it is a recognition of that right to arbitrate, the importance of individual rights to resolve disputes in a way that the parties choose, that underlies these crossover cases, that underlies the decisions that these tribunals have made, and that has been recognized when that right's been infringed as a denial of justice in a whole range of different contexts, both international and national. And with that, I'm sure that I've gone on overly long. I'm sure that Maxie has the chair now to ask for comments or questions from the audience. And
so a couple of points. One thing that I wanted to comment on is and I think it's implicit in some of these remarks, is why is it so controversial then, right? Why is it that we're seeing such criticism? And by the way, on my email, on OEMed or whatever it is, I just saw it on the way here, Marty Koskaniemi has basically come out and said that Finland, if it were to join the transatlantic partnership and include investor state, would be the equivalent of signing on to the European Union and giving away its sovereignty as he sees it. Now, Marty Koskaniemi is a pretty well-known public international lawyer. I happen to think he's crazy on this point, but what he is, I think, reacting to is at the heart of, I think, your question, which is, yes, it's true that the same sets of issues are at stake generally in BITs. What makes these cases a bit more controversial, and I've discussed the industry's case again in my foreign investment class, and let me tell you, the LLMs from India are absolutely apoplectic over that case. They said they got the facts wrong, that here's the various things that the claimant should have done to avoid the 9-year gap, and that it was an egregious offense to suggest that Indian courts, that pillar of democracy and justice, couldn't get its act together on this point. And if you take a look at the White Industries case, it is sort of the low-end dicta for many more pages. That is a much more excruciatingly detailed look at the Indian courts in set-aside, enforcement, at what the lower courts were doing, what the high courts were doing. So it's the very intrusiveness that I think gives rise to some people's complaints that, yes, this is possible. You can review the court. And by the way, when somebody mentioned it's not as controversial as, say, a treaty or overturning or reviewing the Supreme Court decision, let me tell you, if that were to happen under the NAFTA, there would be people running from the NAFTA tomorrow. That is, the idea of reviewing national courts, even in the United States, which is a strong proponent of these treaties and has had extensive, this is the third most, I think, sued state under investor state arbitration. Just the prospect that these cases would be reviewing national courts and national judges gives a lot of people pause in the United States, never mind when it's the highest court in the land. So that's one part of it. With respect to the what should be the fair market value of this award, part of the problem, I think, is that investor arbitration law is not yet well developed as to what is the proper standard, that is, what is the award should be. We know that fair market value is stated in the BITs for a taking, but there is some controversy as to what is the value of a fair and equitable treatment violation or a denial of justice violation. And of these cases, the only one that found a taking, a classic taking, and there I have some doubts about whether there really was one, is Saipem itself. And so there is a question about what is the value, that the proper scope that you should be measuring to begin with when you're outside of the expropriation context. Now, it's amusing to me, though, that somebody would say that it would be an unusual step for Gabrielle Kaufman-Kohler not to award the full value of the ICC award. Well, that's unprecedented. It's the first time anybody's done it under a bid, so I'm glad to know that it was not, that the usual thing is to give them the full value of the ICC award, but I think they made it up at that time, and it makes some sense, but I'm just questioning what is the proper value. As to the very interesting question of African mining contracts, I totally agree. In fact, one of the articles that I think were a chapter actually by Brian King and Roham Amolo, it's called Enforcement After the Arbitration, Strategic Considerations and Forum Choice, basically says now you have to build in all of these considerations at the very earliest moment, including drafting the arbitration clause, planning for where you arbitrate, and everything else. And part of the game is not just considering the forum state for the arbitration, but how does that coincide with a bilateral investment treaty and forum shopping and nationality, nationality planning. I got that right. And so that all those sets of issues are totally fair game. I think that that is part of the planning process that happens. And what I found useful as somebody who doesn't practice in the area is these two folks both are practitioners, indicating that this is now built into at least their practice, at least as advertised to their clients.
Just very briefly, coming back to the question of why is it that BIT arbitrations, investor-state arbitrations, attract such attention? Why the focus of concern about breaching of the public-private divide? And I think we're all familiar with the usual explanation. Of course, it's because secret tribunals in a non-transparent way make decisions that second-guess sovereign policy choices, and they do so without being bound by precedent. One tribunal can decide one way, another tribunal can decide the opposite way. And there aren't the sorts of safeguards that one might desire, such as amicus participation by NGOs or local communities or what have you, and it can impose substantial burdens on the public fisc. We've all heard that, and to some extent, it sounds plausible when you say it. I'd like to suggest that in fact none of those things are really true. I'd like to suggest that in fact, particularly today, investor-state arbitration has become remarkably transparent. You can watch NAFTA and ICSID proceedings on the web. You can't do that for the U.S. Supreme Court or lots of other courts. Some courts have moved along, but not all have. You can file amicus curiae briefs in many investor-state cases. In many national courts, of course, you can't. In some cases for good reason. You, to some extent, do have the beginnings of a development of a system of precedent. Jeffrey Commission, a very good law firm, has done a careful study of the number of times investor-state cases cite other awards and the like, and come, I think, to some pretty persuasive conclusions that there actually is the development of a system of precedent. And when, if you look at the alternative forums in which public disputes are heard, namely national courts in a bunch of different jurisdictions from which there's no appellate body at all, or commercial arbitrations, how do they really develop a system of precedent? So I'd like to suggest that in many ways the criticisms of the investor-state regime aren't really that borne out by the factual reality, but that in an odd way, it is the very transparency of the investor-state regime that creates such attention and fuels such fire. It is the fact that the awards are published and you can get them on the internet. In languages that are accessible, and that you can watch the proceedings on the internet. That in fact attracts such attention to them that you get the Osgood declaration regarding them, whereas you don't get that about state immunity decisions. That's, I recognize, a counterintuitive hypothesis. It's one that flies directly in the face of the usual criticisms, but I'd suggest that when you look at what the reality of investor-state arbitration is, it has at least as much substance as the orthodox explanation.
And I would therefore like to invite Professor Lucas Mistelis for the closing remarks. As I said earlier, he's the director of the School of International Arbitration at Queen Mary University of London. He's also written extensively on international arbitration, including an article on the very topic of the crossover cases that we've been discussing tonight. It's at the ICSID Review 2013, an article entitled Award as an Investment, the Value of an Arbitral Award or the Cost of Non-Enforcement, an article that has already been cited. So, Lucas.
I think one who delivers closing remarks should not abuse the hospitality of an institution that, or a firm that that provides the framework for a very thoughtful discussion. I have refrained to really make any comments that are reflected in my paper, but the discussion is indeed very fascinating and gave me perspectives that I have not really considered when I was writing the paper. My view coincides to some extent with some of the cynical comments that Jose has been putting forward about the popularity of that sort of remedy, of that second look, and or not. And of course, that second look is in most cases not genuinely a second look. That's very clearly for what, for example, Frontier Services says. You went to court, the court said that the award is not enforceable for public policy reasons in that particular case. You can do nothing in investment context. That was a legitimate reason for the court not to enforce. But where the domestic court actions or inactions, because in white industries there was an application to set aside and an application to enforce, and for 8 years nothing happened. And an award which was worth 4 million became nearly 20 million with interest and everything else. So what was awarded in the end was not as such the not enforcement of the award, but the actions of the court to impede to a line of enforcement. And I think in Saipem, I'm not sort of implying necessarily that the tribunal did that. There is some sanctioning of the state for a particular attitude towards arbitration. So it's not as such a second look, but is certainly an enforcement of arbitration as a method of dispute resolution, and not necessarily the right of arbitration, but the fact that parties made sort of state parties to BITs undertake commitments. And let us not forget, BITs are not made for investors. BITs are risk management instruments for states, so that they can attract investments. Investors have various ways of protecting their interests, including drafting concession agreements the way they think are appropriate. So the states defensively do BITs, maybe not very wisely all the time, as to how they will manage their own risk. And that debate means that it goes back to practice that the state descends into the marketplace, Lord Mastill, and then have to live by the rules of the marketplace. So they engage commercially, they increase their exposure. So I think the excellent paper we have had the chance to read, those of you who have had the ICA Congress papers from Singapore, but also the slightly nuanced, actually very interesting nuanced version that was delivered orally today. And the two comments are a testament both to the excellent scholarship of the speaker of today and in his insights and sort of breadth of knowledge and understanding of the subject matter, but also is a testament to the excellent selection of two commentators. As one of the organizing institutions for this event, I would like to thank WilmerHale for hosting it. I would like to thank them for having that indeed excellent scholar in residence program, which has given opportunity for interaction between practice and theory, something that we should all embrace at various levels. And I would like to thank you for your patience and on an unusually rainy day for London. It hasn't been like that for a few weeks, trust me. So thank you all very much.
Thank you very much, Lucas, for this wonderful wrap-up of the discussion and the very optimistic look on London weather. I would like now to invite you to a little glass of champagne in a moment. But before that, I would very much like to thank all of our panelists tonight. Lord Collins, Lucas Mistelis, Gary Bourne, and of course, above all, Professor Alvarez and Professor Alvarez, our keynote speakers. So please join me in expressing our gratitude and thanks for the